And to those of you who are watching on YouTube and Facebook, good afternoon. I'm going to start today with an announcement. In April, a court found Gerardo Estrada Some of the children, but not all, were related to him. When the abuse took place, they ranged in age from 5 years old to 16 years old. The case came to the attention of law enforcement when one of the children, who was just 12 years old at the time, was hospitalized with suicidal ideations. Just this week, the court sentenced Estrada to 281 years in prison with no possibility of early release. You know, somebody who has prosecuted these crimes, I know that these children are going to carry the scars and the memories of what happened to them for the rest of their lives. It took incredible courage for them to come forward and tell their stories, and I want them to know it is a true act of bravery. I am very proud, however, of the professionals in this office, from support staff, paralegals, prosecutors, victim advocates, etc., who were able to come alongside these children, these brave survivors, and give them a voice, allow them to talk about what happened to them so that justice could be done. So I have a second announcement before I open this up for your questions. This morning, my office filed a motion asking the Arizona Supreme Court to set a briefing schedule in anticipation of my office asking the court to issue a warrant of execution for Aaron Brian Gunches. In November of 2002, so just about 22 years ago, Gunches kidnapped a man named Ted Price. He took him to an isolated area of the desert, and he executed him by shooting him. Gunches has exhausted all appeals for his execution at this time at all levels of the criminal justice process. There is no legal basis to delay this any longer. For those of you who are unfamiliar with the timeline on this case, I want to go over it because I think it's very significant. In 2022, Gunches himself filed a motion requesting the Arizona Supreme Court to issue an, quote, immediate death warrant for his execution. Then Attorney General Mark Brnovich joined that motion, agreeing that the requirements for issuance of a warrant had been met. In January of 2023, Gunches, now through advisory council, asked to withdraw his motion, stating that he would not have requested the warrant of execution had he known of the new Attorney General's plans to pause executions. The Attorney General also filed a motion to withdraw the request that her office had made under the previous administration for a warrant. The victims, however, through their attorney, objected, stating that, quote, the attempt to deny justice and finality to victims under a manufactured need for a review of the protocol by the Attorney General and the Governor is unconstitutional. My office filed a brief in support of the victim's position at that time. Because Gunches had exhausted or waived all state and federal appeals, the Arizona Supreme Court followed the law, and they issued a warrant of execution. However, it was allowed to expire before the execution could be carried out. On June 6th of 2023, Ryan Thornell, who is now the director of the Arizona Department of Corrections, Rehabilitation, and Reentry, which I will refer to from here on out as ADCRR, was testifying in front of the Arizona State Senate in order to be confirmed as the director of that agency. At the time, he said this, quote, operationally, the issues, the questions, the concerns that I had as the director have all been resolved. We have gone through all of our review, all of our preparation. We have put the necessary staff in place. We've made contact with the necessary individuals so that we are operationally prepared as of May 5th, and he's referring to 2023, to carry out an execution. The final step that would remain if a warrant for execution was issued is the compounding of the lethal injection drugs, but that has to be timed to the execution period because of the shelf life of those drugs. We engaged then in conversations with the ADCRR, but we learned through those conversations that they had not secured the services of a compounding pharmacist, which would be necessary. Therefore, upon learning that, we did not request a warrant of execution at that time in order for them to have time to complete this step. It was reported in the press that the commissioner's report that was asked for by Governor Hobbs was to be completed in December of 2023. If you recall, in January of 2023, Governor Hobbs had asked David Duncan, who was a former federal court judge, to conduct a review of Arizona's execution protocols. So it was to be done, as it was reported, December of 2023. My office cooperated with his review. We allowed him to interview our attorneys. But then December 2023 came and went, and there was no report. In another conversation with ADCRR in February of 2024, we learned that they had secured a compounding pharmacist. They said, however, that they needed to train some personnel. And based on that conversation, we again waited to request a warrant of execution. 3 weeks ago, however, a letter was sent to the Maricopa County Attorney's office from the Attorney General, who informed us now that the report from David Duncan may arrive early next year, 2025. And in her letter, she said that the executions might resume in the first quarter of 2025. Ted Price's family and friends have waited for 2 decades to see justice and to find closure. I have been patient as the AG and the governor have delayed again and again. But it's been long enough. Ted Price's family has waited long enough. It is unusual for a county attorney's office to request a death warrant. That responsibility is normally shouldered by the Attorney General's office. But you should remember, my office acts on behalf of the state every time we prosecute a criminal felony. My office brought the charges against Aaron Guntis, and my office obtained the conviction. He admitted to shooting and killing the victim, and a jury on 2 different occasions found that a death sentence was appropriate. I am not willing to wait any longer. I've asked the Supreme Court to set a briefing schedule in anticipation of our motion to the court to issue a warrant of execution. So the way this is going to proceed is I will first take questions on this topic, and then we'll get to other topics if time permits. And I apologize, I am on a bit of a tight schedule today. So, yeah.
Hi, County Attorney Mitchell. I just want to make sure I got that right. Okay, you said you're going to be requesting a briefing schedule from the state Supreme Court in anticipation of your motion to issue a request for a warrant of execution from the, is that how it would go? Your motion would say?
The way I would word it is we've asked for a briefing schedule in anticipation of our request for a warrant of execution.
Okay, so you're going to request a warrant of execution. You do that from the state Supreme Court?
Yes.
Right? Okay. So you must feel that you have the right to do that legally?
I believe we do.
can you elaborate on, you guys looked it up, and what did you see, or what is in the law that you think allows you to do that?
The law allows the state to do it. The county attorney represents the state. And in fact, specifically represents the state in this case, in the sense that we prosecuted the case, we brought the charges, and we also have the right to come alongside the victim and ensure that victims' rights are complied with.
Okay. Has anyone ever tried to do this before, you think, from the county level?
I'm not sure that anybody's ever had to try to do this before from the county level.
I get your point, but seriously, do you think this is unprecedented, or do you remember, I know...
I'm not aware of another situation.
Okay. And then, again, for clarification, when did DOC tell you that they had found a compounder?
That was in February of this year.
Okay, so they told you in February of this year that they had a compounder?
Yes.
Okay. Do they have the pentobarbital necessary?
My understanding is they have everything necessary for the execution to be carried out under the protocols that have been approved through the litigation that was done in federal court.
Okay, so in other words, the reasons that they had remaining, you feel that they have taken care of those issues?
They said that they have taken care of those issues. Yes.
That's what they told you. Okay, got it. Okay, thanks.
Mm-hmm.
This report that you mentioned from the judge, do you have any idea what the time frame is for when it might be complete, or if it's still being done, or what the status of that is?
There hasn't been a whole lot of communication on that. I know that we complied with the request for interviews of our people sometime in mid last year. I also know that one of the people that he interviewed was the mother of Vicki Lynn Hoskison, who was raped and murdered by Frank Atwood. Mr. Atwood was executed in 2022, as I'm sure you're aware. That interview took place in September, and at that time she was told that she was the last person to be interviewed. So what we are being told now, being informed of by the AG letter, is that we're looking at next year now. So that's the best I can tell you.
On additional topics, if that's okay.
Okay, look.
Actually, let's finish up anything. Does anybody have any other questions related to gotchas?
Okay.
We'll breeze through these. County Attorney, first off, Palm Valley Post-Acute in Goodyear is where a patient was allegedly raped and impregnated. That case was submitted for charges of sexual assault earlier this year. Where are you guys at with the case against Bobby Lee Williams?
That case was reviewed, and it was turned down for charges because there is no reasonable likelihood of conviction.
Wow, and when did that happen? When was that?
May the 6th.
May 6th. So now Goodyear can get back on it, resubmit it. Is that?
Absolutely. As you know, sex assault charges have no statute of limitations. And so if there's additional information, we'll certainly look at it. But at this point, yes, we've concluded our review of what exists at this point.
Can you say exactly what it was as the reason why it was turned down?
I would urge you to perhaps review the police reports, but bottom line is there were significant evidentiary issues that convinced us that there was not a reasonable likelihood of conviction. And that's about as much as I'm going to say on that.
Okay, this morning there was a hearing regarding Lori Vallow and her murder conspiracy case. Trial set for August 1st. Public defender says he still has about 90,000 pages of documents, and there's like 15 terabytes of discovery. There's a lot to go through. Yeah. Is it foreseeable that this trial gets moved back, or would you like to see this prosecuted on time?
Obviously, I totally understand that, victims want, a fast resolution to cases. But as I have said in the past on other cases, I would rather see it done correctly and be appeal-proof than to be done quickly. And I certainly understand, having sat through numerous briefings on this case, it is a complex case. And so I certainly understand why it would take some time to review. So yes, I do anticipate that it would be continued from this trial date.
I'm sure you're aware of the Chad Daybell verdict over the weekend, guilty and sentenced to death. In his trial, there was a lot of testimony from Chandler police, and it was clear that he has not been charged in these murder conspiracy cases, but the witness from Chandler police indicated that the belief is still that he conspired. Could investigators still resubmit this case against him, or has that been put to bed?
Absolutely, they can resubmit it. At this point, he's been, as you know, he's been given the death penalty in that case. But if any additional information came out of that trial or any other additional information becomes available, absolutely they can submit it and we can reconsider it.
And then lastly, kind of similar in this realm of religion and doomsday beliefs, the Thibodeau, Snar, and Hale sentencing that happened recently, 18 months of probation and 9 months probation, I believe, respectively. This was a family that it was considered custodial interference, but basically kidnapped this child, went to Canada. They were sleeping in their car in freezing temperatures. With what you know and what we've learned from a similar case, do you think this sentence was too light?
I think this illustrates that even though the prosecution is the one that's asked about resolution of cases, that we're not the only player in the system. We did ask for additional time. The judge made the decision to do the 18 months in one case, the 9 months in the other, and we respect that.
Additional time for probation, not jail time.
These are probation eligible offenses, as you well know, I'm sure. Yeah.
Thank you.
Okay, Jazz is up.
Okay, so given the proposed HCR 2060 measure, how do you see this impacting your office's approach to prosecuting immigration-related offenses?
Well, obviously, there's a lot of things that have to happen first. Let me start off by what was sort of the main part that we were looking at in that particular resolution, and that was the fentanyl homicide provision. We've been wanting that for some time. Unfortunately, there was a modification made to that portion of the bill after the initial press conference that I think makes it very difficult to proceed under that specific part of the bill. As far as the other portions, as you know, with one exception, the rest of it has to go through constitutional scrutiny, if you will, because it's based on the Texas law. And so we're going to be watching that, watching how the courts rule, and following that very closely. And that's assuming, of course, that the people vote to make it law.
You mentioned the fentanyl part of it getting changed. Are there any other specific challenges that you anticipate continuing on with this, or?
It kind of depends on how it's looked at by the courts, how it's interpreted by the courts during this challenge. I also understand that there was a challenge filed in Arizona court as well, so that we're going to have to watch that to really, I would be predicting it a little bit early, but I do think the fentanyl portion, as amended, is going to make it very difficult to use that section.
And then my next question, how do you intend to work with local law enforcement to provide the necessary training and resources to uphold the constitutional requirements?
The same way we work with local law enforcement on every other type of case, we're going to have an open stream of communication that has been really a hallmark of this administration. We're going to, if there's any training necessary, we will do training. We will have roundtable discussions as necessary to make sure we're all on the same page, that we're complying with the law, that we're complying with the Constitution, that we're upholding people's rights. That is extremely important to me, and we will do that at that time.
Yeah. Could you provide any more details, if you have any, about how your office plans to collaborate with federal and local agencies to effectively identify and prosecute any offenses?
Well, essentially, those will be submitted to us. So it wouldn't be a matter of identifying, it would be a matter of prosecuting. And again, the same answer applies. I mean, we have to look at how this works its way through the court system in Texas, and both Texas and here. But I will tell you, the fentanyl portion of the bill is problematic.
Thank you.
County Attorney has time for one more question. Amy, go ahead.
Just following up on that, we were looking for some clarification on how you viewed things, the Secure the Border Act. The first part of it said that a person may be arrested for a violation of this section without probable cause, any other constitutionality of probable cause. What does that provision mean, or how did you read that?
Well, I have it in front of me. You said without probable cause?
Yes. It might have been a typo on my part.
I think it's a typo.
It was on line 11.
Hang on a second. I think I have that bracketed. I believe it says with probable cause.
It might say 11.
Right, okay. I'm trying to find the section that you're referring to. I know what you're referring to, but I believe it's a with probable cause.
It might be with. It's on the first page, I believe.
It's on the first page.
Yes, line 11. I think maybe section 3 or section C.
I'll tell you what. My memory of it was that it said with
Okay.
probable cause, and it gave a couple of examples of how that probable cause could be established, and then it also has a third example in there that says, any other constitutionally appropriate criteria. So to me, that's really just a recognition and maybe an emphasis on what the law is, not just the statutory law, but the constitutional law, that there has to be probable cause to arrest someone, and it has to be constitutionally appropriate probable cause. That's my understanding of what it says. If it does say not, give us a call and I'll get on the phone with you, okay?
Okay, I just wondered if it was purposely vague to kind of allow for different situations that might arise.
I don't know how you would be more specific and yet capture like the totality of types of evidence. I'm not sure. I think it was probably to reiterate what the constitutional standard is. But you know what? I would refer you, if you have any specific questions, like why was that included, to the legislature, and I think they would be in the best position to answer exactly why it was drafted like it was.
Okay, Great. Thank you.
Sure.
Thank you. Rick's gotta go.
Yeah.
Oh, because you knew that the defense counsel is supposed to go through 90,000.